Thanks, and let's move on to the program. Can you show us the agenda today, Kathy? Okay, so here's what we've got today for you. We're going to talk right now with a very timely topic from Mark Berman out of our Buffalo office about the ethics related to ChatGPT. If you follow the news at all, there's lots going on at the maker of ChatGPT this week. But he's going to talk more about the product than what's going on with its creator. And then we're going to, Mark's in Buffalo, then we're going to move on, stay in Buffalo with Brendan Goodwine, who's going to talk about a new New York State labor law regarding intellectual property. Teresa Rosnack in Rochester, a frequent contributor here, is going to talk about workplace safety. And then I'm going to wrap things up talking about a decision I think that just came out that I thought was kind of interesting and wanted to share. So with that, I'm going to send it west down the thruway to Mark, who is a recent addition to Schoeneck King. Happy to have you as part of our team, Mark. And I thought you were in Buffalo and you're in New York. And so now I'm going to apologize for that. So other direction of the state. Today's just going great. So go right ahead, Mark. I don't know what I was thinking. But what do you have for us today about ChatGPT?
Well, rather than go west, just due south for a couple 100 miles to Manhattan. Hello, everybody. Okay. No problem, Christian. Mark Berman. Want to talk a little bit about ChatGPT. It's been in the news, in case law, articles, the CEO of different AI companies. But I wanted to sort of frame the issue for everyone to understand. What is ChatGPT? It's a platform. It's a generative AI platform. What do lawyers and clients use it for? They plug in the problem, they ask for help, and it actually generates text to answer your questions. Clients are using it and lawyers are using it. But I'm here today to talk to you about the legal ethics of ChatGPT, which both attorneys, practitioners, judges, and clients should know about. So if you ask ChatGPT the following question, what are the ethical rules for New York lawyers using ChatGPT? It answers, as of my last update, it's September 2001. Let's focus on that. So it's been last updated in 2001. So the free version is already 3 years out of date. There were no specific ethical rules in New York or elsewhere that directly address the use of AI tools like ChatGPT by lawyers. However, it is essential for lawyers to adhere to their professional ethical obligations when using AI tools in their practice. Ethical considerations generally include competence, confidentiality, and the duty of communication. ChatGPT will also tell you, to mitigate risks, it is crucial to use AI tools like ChatGPT responsibly and thoughtfully. Users should critically assess the information provided, be aware of potential biases, and avoid using AI for activities that could be harmful or unethical. So what happens now? You plug in a situation, a program, and what it spits out. And text. So it has to think of what are the problems and what are the ethical problems? One, is ChatGPT secure? If the information you put in there, is it hackable, secure? ChatGPT has been hacked, where hundreds of thousands of users' input has been released to the bad folk through a hacking of their system. Is it secure? Hopefully better now. Is it confidential? No. If I enter information into it with a client name, and Christian enters into information with a client name, and Brendan does the same thing, it commingles all this stuff, and it could be read and analyzed, and it's training itself on information. So you have to be very critically aware that whatever you put into ChatGPT to define your problem, to ask for an answer, there is no confidentiality. Is the information saved, or is after you put it in, does it go poof and disappear? It's saved. So think about it. You have security concerns, it's saved, and it's not confidential. And it actually has been hacked in the past. You've also read, and it's been all over the papers, that chat GBT hallucinates. What does that mean? You ask it to spit out a document, text, case law. It makes up the case law. It had the database is antiquated, and that it's only current to 2021, but it actually comes up with concepts and makes up the names of cases and assigns judges to them. That is a problem for litigators, for court submissions. So let's step back on the ethics. Should a lawyer and clients use chat GBT? It saves time. But saving time is one thing, but one has to look over the output, the cases, the decisions. They could be out of date. So in the end, it does save time, but how much time, I don't know, because one has to do your due diligence separate and apart on the output, on the integrity information, the citation information. And we've heard judges in different courts in the United States sanctioning lawyers for submitting a chat GBT generated brief where they did not follow the ethical precepts of reviewing it to make sure the information is current and up to date. That's not to say one shouldn't use it if one wants it to do an outline for a presentation, wants to do a memo and learn certain rudimentary concepts. It's a good foundational start. But as far as using it unchecked to submit court documents, I would not recommend it. I step back, and the Florida Bar has asked their members to comment on the following questions. And this is interesting to lawyers and clients. Whether a lawyer is required to obtain the client's informed consent to use generative AI in the client's representation. A very, very interesting question asked of the Florida Bar. Also asked of the Florida Bar is whether a lawyer is required to supervise generative AI and other similar large language-based technology programs pursuant to standard applicable to non-lawyer assistants. And lastly, near and dear to everybody is the question that Florida asks us for. The ethical limitations and conditions that apply to a lawyer's fees and costs when a lawyer uses generative AI or other similar large language-based technology providing legal services, including whether a lawyer must revise their fees to reflect an increase in efficiency due to the use of AI technology, and whether a lawyer may charge clients for the time spent learning to use AI technology more efficiently. That's a thumbnail of chat GPT, the ethical issues that it raises, some of them that are not intuitive. One has to think about it. Lawyers, judges, and clients have to know what's out there to really see if it's appropriate to use chat GBT under the circumstances of your assignment. Christian, I think that gives us a little thumbnail, encapsulates where we are. I think over time, there's pay models that are more up to date, and big law and big corporations are thinking about creating their own in-house AI, databases. And of course, if that were the case, issues about hacking, confidentiality, and security are much, much more limited when it's not this publicly accessible platform.
Thanks a lot, Mark. Appreciate it. We hear a lot about AI, and we're going to continue to hear about it. So it's good to keep it top of mind. Appreciate it. Our next presenter is, you turn the slide, Brendan Goodwine. For a second, I forgot the order again. Today's going to be fabulously. So Brendan is an associate. He really is in our Buffalo office, unlike Mark. And there is interesting new labor law regarding intellectual property. Brendan focuses on intellectual property. And so let him tell us about it. So take it away, Brendan.
Thanks, Kristen. So hopefully you all can hear me all right. Let me know if not. I'm an associate here in Bond, Schoeneck King, but I've been working in intellectual property since about 2014, so going on almost 9-10 years now. And I'm licensed in Ohio and New York. Chris or Kathy, if you want to move to the next slide. So this is a new labor law that I'd like to talk with you about. It was just passed recently this past September, and it has to do with whether or not employees are required to assign their intellectual property rights, specifically their patent rights, to their employers. And this was sort of the justification given in the bill, where there was this concern about overly broad contracts robbing employees of their intellectual property, and wanting to protect employee rights and inventions separate from their employers. They do know that in California, a similar protection, similar labor law was also passed back in 2011. So we'll touch on that a little bit. So what does this law actually say? Kathy, next slide, please. So it's relatively short, but we're going to break it down. Essentially, any provision in an employment agreement that provides an employee shall assign or offer to assign any of their rights in an invention shall not apply to an invention that the employee developed entirely on their own time without using the employer's equipment, supplies, facilities, or trade secret information. There's a couple of exceptions, which we'll talk about. And then the effect of this new labor law is ostensibly that provision requiring assignment is not enforceable. And I will note this law was effective immediately, so this is currently in effect. So what does this all mean? Kathy, if you want to forward one slide. So thank you. The first kind of section that I want to break down is what a qualifying provision in an employment agreement looks like. So first, you have to have an employee. Under this law, it's not really clear whether or not it applies to independent contractors. So right now, just based on the plain language, you have to have an employee. You have to have a provision to assign or offer to assign any rights in an invention to their employer. So those are the sort of four qualifying provisions. Those provisions will not apply to inventions that are developed entirely on the employee's own time and developed without using the employer's property. And that, from the previous slide, we'll talk about it a little bit more in a minute, but what employees are allowed to use is very interesting. And then the exceptions, if an employee or an employer can still kind of claw back those inventions if, for example, an employee develops it on their own time outside of work hours, but the invention relates to the employer's business, then the employer can still require them to assign those rights. Same for inventions that relate to the employer's actual or quote unquote demonstrably anticipated R&D. And then any inventions that quote unquote result from any work performed by the employee for the employer. Now these are, seems fairly straightforward, but I think it gets into kind of the factual scenarios in each of these cases. But there are a couple of takeaways that we can generalize just based on what the statute says. Next slide, Kathy. So I think there are three main takeaways. The first one being asking, are your IP provisions still enforceable? So if you have employment agreements that have patent assignment provisions, I would take a look and say, are these overbroad under the new labor law? Do we have IP provisions at all? If you don't have IP provisions, maybe obviously that won't be a concern for you, but maybe you do want IP provisions, and how do you craft those to not capture inventive work that is done outside of the employer's gambit. The second one, or the second takeaway, would be, are your employment agreements as a whole still enforceable? So one of the big concerns here is whether or not your employment agreements include a severability clause. If they do not, then your entire employment agreement may not be enforceable anymore based on this labor law. If your employment agreements do include a severability clause, then and your IP provision runs afoul of this new labor law, then you're probably okay. Your you won't have to re-execute an entirely new employment agreement. The third question, which develops out of this law, is, are your employment agreements adequately protecting your business's confidential or proprietary information? And now I mentioned before that the new labor law protects employers' property, but it doesn't protect all of the employer's property. Specifically, only exempts inventions that are that rely on the employer's equipment, supplies, facilities, or importantly, trade secret information. But there are things that qualify as, for example, confidential or proprietary that may not qualify for trade secret protection. So one of the important takeaways is, are your employment agreements separate from your IP provisions adequately protecting your confidential and proprietary information? And going just one note, going off of what Mark was talking about, this is especially a concern with new AI platforms where employees may be entering trade secret, confidential information, or proprietary information into these databases that are not preserving those confidentiality provisions. There was, I believe it was Samsung, there was a recent case where employees were entering in confidential information, and that was getting spit back out to other users of the platform. So yeah, I think that kind of gives us a quick 10-minute overview of that new IP law, labor law, and a couple of quick takeaway action items. Kathy, next slide. I think that might be the end. Yep. So I'll hand it back to you, Kristen.
Okay, thank you, Brendan. Hoping my audio is a little better. I did get some feedback that I was echoing, so let me know if that's still a problem. But in the meantime, we have another presentation for you from Teresa Resnack about a new workplace safety partnership between OSHA and the NLRB. We've seen in the past where our federal agencies like to talk to each other, and it looks like that's what's happening again on the issue of safety. So, Teresa, tell us about it.
Great, thanks, Kristen, and good afternoon, everyone. Kathy, if you could go to the first slide, please. Okay, so as Kristen mentioned, the Occupational Safety and Health Administration, or OSHA, and the National Labor Relations Board have entered into what they're calling a Memorandum of Understanding. I'm abbreviating it to MOU with one another. They entered into that on October 31st, Halloween of this year. The purpose, according to the agencies, is to strengthen their partnership to promote safe and healthy workplaces through protecting the worker's voice. This comes as part of a larger series of memorandums of understanding between the National Labor Relations Board and other agencies. For example, they have one with the Department of Labor's Wage and Hour Division, and they're looking to enter them with different federal agencies. Next slide, please. Just as a recap for everyone, OSHA is a federal agency dedicated to ensuring worker safety at work sites across the country. OSHA has jurisdiction over the enforcement of dozens of laws. People think it's just the Occupational Safety and Health Act. It's not. They have jurisdiction over dozens of laws in almost every industry. OSHA can perform inspections and can also issue fines and penalties to any employer under its jurisdiction. The National Labor Relations Board is another federal agency. It's dedicated to protecting the rights of private sector and private sector employees to join together with or without a union to improve their wages, hours, and working conditions. So the NLRB and the NLRA, the acts that it enforces, are going to apply to both unionized and non-unionized workplaces in somewhat different ways. So those are what those two agencies basically do. This is an announcement that they've decided to work together. And I'll talk a little bit more about that on the next slide, please. So just continuing to talk about the agencies, there's been an increase in both NLRB and OSHA activities under the Biden administration. So the fact that this MOU has been entered into is not exactly surprising to me, or I think to many of my colleagues. This is a continuation of what the agencies have already been doing in terms of collaborating with one another and making sure that complaints and concerns are adequately investigated and remedied. Both agencies have the ability to investigate and enforce penalties, particularly for retaliation claims. So both the NLRA and the OSHA Act, or Occupational Safety and Health Act, protect employees' rights to complain to management about unsafe or unhealthful working conditions. And that's really where the majority of their overlap is. OSHA protects that right from a safety perspective. You have a right under OSHA's various laws that they enforce to make complaints about safety concerns to management. And then you have the same right under the National Labor Relations Act, which the NLRB enforces because that's considered a type of protected concerted activity to improve the working conditions in the workplace. So you have that basic right under both laws. And that's what this memorandum of understanding really focuses on. Next slide, please. So some of the protocols for exchanges of information between the agencies are set forth in the memorandum. So OSHA is going to provide potential victims of unfair labor practices with the NLRB's contact information. So if OSHA comes to your worksite or they receive a complaint from an employee and they say, well, you know, this looks like it could be an unfair labor practice. It looks like the employer was unfairly targeting people who are pro-union, for example. If OSHA gets a complaint like that, they're no longer going to just set it aside. They're going to provide that person proactively with information about how to contact the National Labor Relations Board, which would have jurisdiction over that type of claim. In a similar way, OSHA is going to advise individuals who file time-barred claims that they may still file a charge with the NLRB for 6 months. So OSHA has a shorter time period to file certain types of claims than the NLRB. So instead of OSHA just kicking out a case saying you filed too late, they're now going to refer people to the NLRB to see if they could potentially file there. And then the NLRB is going to share information with OSHA regarding workers who are likely exposed to health and safety hazards or to suspected violations of OSHA regulations, and encourage those workers to contact OSHA promptly. So basically, these agencies are going to be kind of lookouts for one another to the extent that they get complaints from individuals or complaints about certain industries and companies. They're going to be looking to share that information with the complainants so that the complainants can go and file a different type of complaint or can know what their rights are under all potentially applicable statutes, not just the agency that they decided to file with. Next slide, please. The Memorandum of Understanding generally envisions opportunities for OSHA and the National Labor Relations Board to work together on inspections and investigations, and to confer with one another on appropriate jurisdictions. Sometimes it'll be an OSHA case, sometimes it'll be an NLRB case, and sometimes the case will have aspects of both OSHA and NLRB enforcement. The agencies are also going to engage in joint public engagement, outreach, and education, and they're going to train each other's personnel. Now, I don't know that necessarily means if you have an OSHA investigation, if they're going to start asking questions about protected concerted activity under the NLRB or vice versa. But I certainly think, given this memorandum of understanding, it's something you're going to want to prepare your supervisors for. Next slide, please. The memorandum of understanding takes effect immediately. It expires in 5 years unless it's renewed, but it's in effect for at least the next 5 years. Employers should expect, in light of this memorandum, that an NLRB investigation could lead into an OSHA investigation and vice versa. You need to always be thinking, if I'm being investigated by one, I might be getting investigated by the other at the same time or right on the heels of that investigation. That's particularly relevant in a couple of different places. You know, for one that I think is more relevant than others is when inspections are conducted by an OSHA investigator. The unions have certain rights to accompany the inspector, and sometimes even unions not affiliated with the workplace have rights to accompany the inspector. So that type of thing is going to be certainly enforced by and increased by this memorandum of understanding between the two agencies. The bottom line for all of my employers listening, and I can't emphasize this enough, if an agency shows up at the door, whether it's OSHA, the National Labor Relations Board, the Department of Labor, whether it's federal, state, New York State unemployment, whoever it is, you need to be prepared for what happens next. You know, I continue to see some employers try to, you know, go it alone and, you know, in their best efforts, try to cooperate with an agency that is not necessarily on their side. You know, if an agency shows up at the door, or if they send you a letter saying they're going to come, or there's going to be an inspection or an audit, or that a complaint has been made, I really can't emphasize this enough. Please have a plan in place for what you're going to do. And I highly recommend that plan includes calling your favorite bond attorney or other favorite labor counsel. These are not agencies that are necessarily friendly to employers, and they're not necessarily agencies that are looking to help the employer through this process. So I'll leave you with that and turn it back to Kristen.
Thank you, Teresa. Okay, so I'm going to finish things off today and talk to you about a recent decision involving a service animal that caught my attention. It's not a New York decision, but I find that service animals and emotional support animals are a topic that clients are really interested in these days. We're seeing more and more employees coming and asking for the ability to use these animals at work. I will say that the title here, decisions, plural, is due to time has been pared back to one decision. So I'll tell you what, we'll talk about one decision today, and I'm here every other week, so I'll save the other ones for a future week. This case came out of Detroit and involves a nursing student, actually an undergraduate nursing student who was performing her required placements at a hospital in Detroit. It was a federal court case decided by the 6th Circuit, which is the federal appeals court that covers Michigan. So of course that wouldn't apply directly in New York, but it's an interesting case nonetheless. And I think we can learn some lessons from it. So this hospital, this nursing student had panic disorder and had a dog named Pistol. And Pistol was trained to recognize her panic attacks as they would start sooner than she could necessarily notice them. And that would cue her to take her medication. And if she was warned by Pistol, she would have a shorter episode of her panic attack. And so this was important for her. We've talked a lot before about the difference between service animals and support animals. A service animal is one who is trained to specifically assist their owner in a particular life activity. And, this would qualify for that, a dog that's specifically trained to provide a warning of a need to take medication, as opposed to an animal that's just there to provide comfort. There is a distinction there. And so initially the hospital had a very good, very compliant service animal hospital. Now, of course, here we're not talking about employment law, but it's very much analogous. The laws that apply to a student and the student's rights are very similar under the ADA. So the lessons are applicable. So the hospital had a policy and initially approved the use of this service dog. And on the very first day that the student came to the floor, a common concern that employers raised to me actually happened, which is a co-worker, or a nurse in this case, had a very severe allergic attack. And it was so bad that the nurse had to go home and missed several days of work. Additionally, a patient had a reaction. And so the hospital is left thinking, now what do we do, right? I mean, we're trying to be compliant with the Americans with Disabilities Act, but we can't, what do we do? Do we move this nurse? Do we move this patient? Our lawyers tell us that we need to allow the service animal. So they did a lot of things right here. And the punchline at the very end is the Americans with Disabilities case against the hospital was dismissed. The hospital won. The hospital did the right thing here. And so because what they did was, after they initially approved the service animal, and then they had these issues, they sat back down with the student and said, listen, we have this problem. We have some severe allergic reactions happening. Let's figure something out here. And the student said, I have an idea. There's something called a shed guard. I'm not familiar with this, but apparently there's something you can put over your dog that would reduce the release of allergens and should take care of the problem. So great. So the student went off to evaluate the shed guard and didn't come in the right size for this dog, unfortunately. And so the hospital was left to figure out, okay, what next? Do we just tell her no? And no, they actually did what I always encourage employers to do, which is to think creatively, think of alternatives. And what they thought of was, well, we'll allow her to bring her dog, crate the dog in a different location in the hospital, and take both scheduled and unscheduled breaks to see the dog. And the student said, no, that doesn't work for me. The whole point of the dog is for the dog to be with me, to recognize the panic attacks that are coming. And so having the dog off in a crate somewhere else in the hospital does me no good. Eventually they come to no agreement, but the dog is not allowed. She does finish her rotation at the hospital successfully, goes on, does another rotation with the hospital without the animal successfully, no panic attacks. But she did eventually come back and, bring a lawsuit against the hospital saying that this violated my rights under the Americans with Disabilities Act to have a service animal and have that as a reasonable accommodation for my disability. So the court did in the end decide that the allergic reaction of the others in the workplace were sufficient to show that this animal posed a direct threat in the workplace. And you don't find these in the cases a lot. I don't know how many times I've told clients, geez, the allergic reaction of other people, it's kind of not enough to say no. It really usually isn't. But here, I think it was a very unique set of facts, which are, we're in a hospital here. You're dealing with nurses that are unionized. They have a collective bargaining agreement that makes it more difficult to just move them to a different floor. So they couldn't just pick up and move that other employee. You don't necessarily know which patients are going to be sensitive, which ones might be immunocompromised. This floor was providing dialysis to patients, so some patients needed to be on this floor and no other floor. And so those are some unique facts, but I still think that this case is really instructive for a couple of reasons. One is the thing I already mentioned. They did not just say no, they were creative. And the court specifically said the fact that they came back with another suggestion of how this might be handled shows that they were participating in good faith in the process. I think that's incredibly important. If you think that perhaps the dog in the workplace or any reasonable combination isn't going to work, try to come up with an alternative, because you have to remember that it's not always that you provide the requested accommodation for an employee or a student. It's one that works, and it can be something different. And the other thing is they didn't apply, and the court specifically mentioned this, they didn't apply a blanket policy. Although they had a policy, they looked at this in a very individualized basis. They sat down with the person, they had conversations, they thought they tried to come up with alternatives. So I think the lessons learned here are that just to don't apply blanket policies, to be creative, engage in good faith, try to find a solution. And sometimes it won't happen. And if you do have a unique set of circumstances like this hospital where, the allergies are unavoidable and cause harm, perhaps, you can take the same path as this hospital. Would this 100% come out the same way in New York? Always hard to say. In New York, a court might look at it differently, but wanted to share it, thought it was interesting. We don't get a lot of these service animal cases in our federal courts yet. So I hope you enjoyed that and learned something new. With that, I'm going to wrap things up today. If you have any questions, I encourage you to reach out to any one of our presenters whose contact information can be found on the next slide. And thank you again for joining us, and wish you all a very nice Thanksgiving. Hope you're able to spend time with the people that you love to spend time with. And I'll see you again in 2 weeks. Thank you.